talking to Venditti at Hawbecker and Garver, one of the attorneys over here, and I'm going through some changes to the 8.0 contract, or just going over some of the pertinent portions of the contract. Right now, today, I'm going to be speaking to you about paragraph 17, which is the association condo documents, what's required. So I'm going to go ahead and share my screen with you so that you can see exactly what we're talking about. All right, I have it pulled up. So this only applies to properties that are in a condominium or a common interest association or a homeowners association. All right, so we're going to go ahead and start with paragraph A. All right, so they're saying that title will be good once they have received all of the documents from the association that's pursuant to the declarations and the CCRs, what the rules state in those. So the title company has those, they're reported against the property. All right, so that's something you should know there. All right, B is talking about who is responsible for the assessments. So this is a good thing to note. If there are any past due assessments, so any regular assessments due prior to closing, are the responsibility of the seller. So that seems like that should be common knowledge, but just so you know, now you can negotiate that, of course, but just so you know, they have to have those paid in full at the time of closing. The same is with special assessments that are confirmed before the date of acceptance. So if there is a special assessment, it passes the day before acceptance. That is the seller's responsibility unless there is some agreement otherwise. So the faster you can get association documents in general, the better. As an agent, if you can reach out, I know a lot of our city agents do this, but if you reach out and you just find out who the association contact is, get that over to your attorney. I know our office is going to order them immediately. The faster we get those, the better, just to see if there are any surprise issues. We'd rather on getting that done. Same way that the buyer can then turn around and see some of those things. That's how they see the rules and regs, if you're able to get those ahead of time so you don't have any issues where once we finally do get them, they've decided that there's an issue with the property, which we will get to. All right, I'm going to go ahead and scroll down until we get to C. All right, so if after we have come to acceptance, we have a contract, before closing, if there is a special assessment or an increase in the regular assessment, you have to let the buyer know. All right, so then the parties have 3 days to negotiate. The buyer does not automatically have to take that on. So if they pass a special assessment day after acceptance, you now have to turn around and negotiate that with the buyer. You don't automatically have to pay it. You get 3 business days to do it. Now, after the 3 business days, the contract doesn't automatically cancel. So if for some reason you are having a hard time coming to an agreement, but you're equally working on it, it doesn't automatically cancel. It just says that they may cancel. All right. Same way with a regular assessment. We have this happen, especially at the end of the year, towards the beginning of the year, where you will have the association will pass an increase in their yearly assessment. So the information that was in the MLS is now different than what the current assessments are. So you have to tell that to the buyer, and they do have the right to ask for something for that. So they can come in and ask for credit for some of the time. They can cancel because of it if an agreement can't be reached. All right, so that's just really important to note. Both parties, though, can declare it null and void. So if you find out there's like a $500 special assessment as a seller and you think any other buyer would be willing to take that on, you do have that right. All right. Next, in D, all right, we have that the seller, within 10 business days after the date of acceptance, has to apply for all of the items that they're required to provide by statute to the buyer. All right, so your attorney should be ordering these documents within 10 business days of acceptance, not after agreement to attorney review. We see this come up all the time, saying that we want to agree to attorney review before we pay to order association documents. I get it. I understand association documents can be ridiculously expensive, but it's it's in the contract that if you don't have it done within 10 business days, technically the other side can cancel because it's a breach of the contract. All right. Now, the contract is conditioned that you are able to provide certain things. One is a right of first refusal which what that is, the association has the right, some associations have the right, depending on the declaration, to buy the unit before somebody else, a third party. If they have that right, they either have to say that they're not exercising it, or they waive it, right? If they don't have that right, they need to say they don't have it. And then the title company will insure over that. All right. Now, the other thing to note is that if you're a buyer and the association requires you to fill out additional forms in order to get association documents, or you have to come in and do a interview, which some of the associations do that a lot downtown, require you to come in and actually sit down and do an interview, meet the association, and they sit down and like go over the rules and regulations and stuff with you. You have to comply to do the same. All right. If not, you can't turn around and try to cancel the contract because of the association documents. You're agreeing to comply. All right. If we come down to E, if the documents provide something that the buyer is not in agreement with, so it violates the rules, the regulations, restrictions, they can't enjoy the property, the financials are not exactly what they thought, and it's going to be way more money. The buyer has 5 business days to review those documents, and then they can let the other side know they have requests that they don't approve until they have additional questions answered, or they can cancel. They also have the right to approve within 5 days. All right. If you don't raise anything within those first 5 business days after receipt, you technically, or you have waived this contingency. All right. And then you have to move forward. And then finally, it's saying that the seller has to provide a certificate of insurance showing the buyer and buyer's lender as additional insured. So this is a big one that we get pushback on a lot with other attorneys, that they'll say you can contact them. It's in the contract. The seller is supposed to provide this if it's an extra fee. So just to go back a little bit, we've gone through just the subparagraphs, but I kind of want to go through and tell you what documents are needed and what they each mean. So the first one that we get, the two that your attorney is most likely going to be reviewing for you, is a 22.1 disclosure and a paid assessment letter. All right, so the 22.1 disclosure, it reviews whether or not there are any past due assessments. Sometimes that'll come up, but mostly we are looking for what the current assessments are, if there's any litigation, if there are any upcoming capital expenditures that the association is going to be doing that they're going to expect to have to pay something for that. So that could be where they're like, oh, in the next couple of years, we're going to need to tuck point the whole building or replace a roof or do an elevator project. They'll also put in there what the reserves are and if there are any reserves earmarked for a specific project. So you may get the 22.1 disclosure, see that they're going to remodel the first floor and that they're putting $20,000 towards that and it's been earmarked. Now you know, hey, they're probably not going to be increasing the assessments or doing a special assessment because they already have enough in reserves and they've earmarked part of it for the actual project. This is when you'll see the big projects coming up that you then have to make the determination as to whether or not you think that there's enough in the reserves to cover it. And, you know, when is it happening? All of that kind of stuff. This is when you can look at all of that to kind of see the health of the association and when you may have an increase in the increase in assessments or a special assessment due on the property because of these upcoming projects. All right, so that's kind of what we're looking at with the 22.1 disclosure. With the paid assessment letter, the paid assessment letter is what's going to tell you how, usually again, I'll reiterate how much is due monthly, yearly, biannually, however it's paid. It'll also tell you how much is outstanding. So it'll tell you the seller still owes this much money and it has to be paid in full at closing. This is when you'll see special assessments that need to be paid in full, all of that. This is also where you'll see the language stating whether or not the association waives their right of first refusal normally. Sometimes there's a separate form, but it's usually all included in the paid assessment letter. It will tell you exactly what needs to happen after closing to the closer. It'll tell them that they need to submit a settlement statement with the checks so that they can switch everything over on occasion. It has all of those instructions normally in your paid assessment letter. On occasion, you will also see in the paid assessment letter whether or not the unit is in compliance as far as the association knows. So that's when you will find out whether or not you they didn't fix a fence on the townhome, or I've had a mailbox that wasn't up to code, something along those lines, or that the railings haven't been completed on the condo association or on the condo unit. That's when you'll start to get into those things. And you can see whether or not you're in compliance. Again, you have approval over these documents as the buyer, so that you can go back and say, this needs to be brought into compliance before I'm in agreement with this document. Okay. Some other things that automatically come to us are rules and regulations, declarations and bylaws, financial reports, that sort of thing, budgets. All right. So the thing is I can give a budget or a reserve amount to one client and it'll have $1 million. Same building, one client's like, wow, they have so much in reserves. And the next client is like, that is not nearly enough in reserves. Obviously, if I'm seeing big ticket items and there's little in reserves, that's going to be something to call out. But for the most part, when we're reviewing these, we're literally just looking to see if there's major items on the horizon that the association is going to be addressing, and whether or not there's approximately enough to handle it. When you are reviewing association documents, the thing that's really important to note is that when you buy in an association, you are technically buying a part of an LLC, an association. So you are now an owning member of this. So it's really important that you review the documents, you understand what your rules and everything that's in the rules governing the association, such as like meetings and voting and all that. It's very important that you understand that. The other thing is like rules and regulations. We are more than happy, and I'm sure any other attorney, your agent, they're going to be more than happy to look at specific items that are in the rules and regulations if you have any questions. But unfortunately, we don't know everyone's lifestyle, right? So we'll have somebody that's very worried about whether or not they can have dogs in the unit, right? I've had people worried about whether or not they can rip up the carpeting and put down hardwood floors. But, you know, if I'm looking at the rules and regulations, I can't tell what's important from person to person. However, when we send it out, we will give you some things to maybe look for to kind of get the ball rolling. And if you have any specific questions, we're more than happy to reach out to either the association to review it and let you know our thoughts, the other attorney, whomever, to try to get any type of responses on those. All right. The other items that we request is a plat. So if you are in a condo, we want to make sure that we get a plat of the subdivision or the plat of survey that shows that where your unit is located and where your parking space is located. If you have a parking space, same with storage or roof rights. So those will show up on a plat so that you can see, hey, this is the parking space that is going to be deeded to me, but I do not see that it's in the same spot as the one I was shown when I went to do my inspection, walkthrough, whatever. So that's when we start to kind of look at that. We just send that to you to make sure that everything is in the right spot as far as you can tell. We're also going to be asking for 24 months of meeting minutes. And obviously we just take as many as the association can give to us. So for example, some associations meet, I've had them meet bi-monthly. I've had them meet once every 6 months, once a year, right? So anything that's come up in the last 2 years, I'm going to see those minutes. The reason is we're going to send those to you for review. We kind of skim them because the 22.1, like I said, has in there if they're going to be doing any projects, right? That they've kind of voted on and decided on. Now, the minutes, though, may show you that they've been tabling a project for quite some time. We're building up reserves to do this. We need to make sure that we have enough so that we can do this elevator project or this roof replacement. Or don't forget, in 2026, we're going to have to redo all of the balconies, right? So it may be something that isn't necessarily has not risen to the point that they need to put it in the 22.1 disclosure, but it's still really good for you to know so that you can ask questions, because there's been plenty of times we see something in the minutes or the client sees something in the minutes that could show potential upcoming increases in the assessments or special assessment. All right, and then the same thing, we also are going to ask for any type of reserve study. Those usually very long, but it tells you what the association is planning. They've had somebody that's a professional look at into all their books and their budgets and everything like that and tell them what they think. In 10 years, you need to replace the roof. And then I think you need to do this, and I need you to put money here. And then you can tell by the minutes what they've decided to do, but it gives you the report so that you can kind of look through and see what a professional thinks they should be on the lookout for. Okay, just the biggest thing to note is, again, you have 5 business days to review these, and it's very imperative that you look into that, make sure that you're comfortable with all of these documents. Again, as you are going to be a part owner, you're going to be living in the property, so it's very important that you review to make sure that everything is to your liking. All right, thanks so much.